New Mexico Broker Basics, page 54. The bylaws of the HOA. 3. The covenants, conditions, and restrictions applicable to the property at issue. And 4. The rules of the HOA. In addition, no later than 7 days prior to closing, the seller must provide the buyer with a disclosure certificate from the HOA. This certificate must include the following. 1. A statement disclosing the existence and terms of any right of first refusal or other restraint on the free alienability of the property. 2. A statement setting forth the amount of the monthly common expense assessment and any unpaid common expense or special assessment currently due and payable from the selling property owner. 3. A statement of any other fees payable by property owners. 4. A statement of any capital expenditure anticipated by the HOA and approved by the board for the current fiscal year and the 2 next succeeding fiscal years. 5. A statement of the amount of any reserves for capital expenditures and of any portions of those reserves designated by the HOA for any approved projects. 6. The most recent regularly prepared balance sheet and income and expense statement, if any, of the HOA. 7. The current operating budget of the HOA. 8. A statement of any unsatisfied judgments or pending suits against the HOA and the status of any pending suits material to the HOA of which the HOA has actual knowledge. 9. A statement describing any insurance coverage provided for the benefit of property owners and the board of the HOA. 10. A statement of the remaining term of any leasehold estate affecting the HOA and the provisions governing any extension of renewal thereof. And 11. The contact person and contact information for the HOA. Upon written request by a property owner, the HOA must provide the disclosure certificate within 10 business days. A property owner is not liable to a buyer for failure or delay of the HOA to provide the disclosure certificate in a timely manner, or for any erroneous information provided by the HOA and included in the disclosure certificate. Upon receiving the certificate, a purchaser has 7 days to terminate the purchase agreement. If the purchaser terminates the purchase agreement, the seller must refund any fees and/or earnest money paid by the buyer within 15 days of termination. A disclosure certificate is not required in the case of a disposition. 1. Pursuant to court order. 2. By a government or governmental agency. Freddie Mac or Fannie Mae are not government entities. 3. By foreclosure. This refers to the court-ordered foreclosure sale. It does not apply to the sale of bank-owned properties, even if the bank/lender acquire the property at a foreclosure sale. 4. By deed given to a lender in lieu of foreclosure, or 5. That may be canceled at any time and for any reason by the purchaser without penalty. Extra notes. Most of this, the title company has it, pointing to the rules of the HOA. CC&Rs are recorded, HOA not really recorded. specifically something special assessments, and that's pointing to the expense assessment and unpaid uncommon expense. Homeowners, I think it's insurance, might not cover the roof. As a lawyer, you something to the info. 30 to 45 days is, if longer than a red flag, is a red flag, and that's pointing to the most recent regularly prepared balance sheet and income and expense statement, if any, of the HOA. If you, a buyer, you want to know that, and it's pointing to the HOA has actual knowledge, something about pending material and unsatisfied judgments and pending suits. And it's not unusual if HOA penalizes in something for common expenses, and it's pointing to property owners and the board of the HOA, a statement describing an insurance coverage